How's jail?
It could be worse.
You're harder to get a hold of than the Pope, man. For real.
What do you mean?
You don't show up. That's what's for real.
I've only showed up not one time. Just one time I missed.
That's cute.
One time.
That's cute.
Except for
Well, Mr. Odom, just ask you
here's the
to not
deal.
speak anymore.
You've now picked up another case. You picked up a violation of a protective order. I don't even know what happened. We're gonna figure it out. All I know is that you have an open harassment with us. While you're on bond with that one, you pick up a felony assault, and now you've picked up a violation of protective order. So, Ms. Garza, please.
Got into a physical altercation with the defendant because the defendant was drinking and becoming verbally aggressive with her. The complaining witness's older son did not like how the defendant was talking to the complaining witness and told him to back off. The complaining witness's son then hit the defendant and a physical fight broke out between the sons and defendant. Officers observed the son's knuckles be busted and blood on his shirt, and the complaining witness is the protected person on the order.
Was that from the assault or was it from the harassment?
The protective order is from the assault impeding breath.
So Judge, as you can see, my client still has visible injuries from this interaction. I would ask that the court set a bond. Mr. Odom is aware, though, that the felony court could revoke his bond, so I don't think he plans on making any bail. But we do ask that if the court would set.
I'm showing he's on bond in our case at 5,001. What? But how? Did they give him a PR bond? Did he make a surety bond? What happened here? On which case? The harassment.
I see a surety bond.
I see a surety bond on the July 1st, Judge, on the harassment. 5,001.
It's weird because it just doesn't.
Financial casualty and surety.
Okay. I want you to know, Mr. Odom, that no means no. I don't care what your excuse is. I don't care what you're doing in life. The Texas Constitution does not allow me, but in extremely limited circumstances, to hold someone at no bond. Zero bond. This is one of those occasions. Ma'am, take a seat, please.
Yes, sir. Sorry.
If you are charged with a violation of a protective order, and I put conditions on that violation, and you violate those conditions that I put on you on the VPO, I can have a hearing to hold you at no bond. Mr. Odom, I want you to know that I'm going to do that in a heartbeat. And I will do everything in my power to protect every single person in Paris County.
Yes, sir.
Do you understand?
Yes, sir.
I'm ordering you as a condition of your bond not to have any contact with any of the complaining witnesses in either the harassment or the violation case, or I'm sorry, the impeding breath case, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a scram ankle monitor on you. Remember this, man. These conditions will all go on the violation of a protective order. If you consume alcohol, I can have a hearing to hold you at no bond. If you get this scram device and you don't charge it, I can have a hearing to hold you at no bond. I'm going to put a GPS monitor. I'm going to give you a curfew and a 1,000-foot exclusion zone from the house in question. If you go anywhere near it, I will have a hearing to hold you at zero bond, and that's what I'm going to do.
Yes, sir.
So, Tracy, he must have a GPS monitor prior to release. I need to make sure that he signs the conditions today. I don't want it to fall through the loop. So we'll have 1 day upon release, he must get a scram ankle monitor. No weapons, no contact with any of the complaining witnesses, no going within 1,000 feet. You must charge both of these monitors on a daily basis. If they die, so do you. Do you understand?
Sure.
I'm gonna set your bond on the violation of protective order at 10,003. You have a cell phone.
I don't.
How is it that the lawyer can get in contact with you?
The only person that I had was her, my wife. It's the only person. I have a phone, but it's not connected.
How do you get in contact with people?
I use her phone.
You can't use this person's phone, dude.
I know, I don't have a phone right now, not until I get out. I can't do nothing while I'm in jail.
What are you doing in life, man?
Oh, right now I'm in jail, so I mean, I'm not doing anything.
What were you doing?
I was a mechanic.
Jillian, I don't know how you're gonna get a hold of Mr. Odom. Smoke signal. You have an email address? Mr.
His,
Odom,
he is aware his felony court date is just next week. And the previous misdemeanor is the day after. So if he were to bond out, I have a note to go up there and just see. I don't think he will, but if he does,
I mean,
I can go.
Jillian, he's made bond on the felony impeding. He's made bond already on the harassment. He must have some kind of lucky charm out there. It's magically delicious that makes all of his bonds. So, you know, it's a matter of time. They're gonna make this bond if you don't remain in contact with your lawyer.
I can't bond out. I'm not bonding out until I go to felony court.
Someone's made both of your bonds here.
Well, she has, but I'm not one from talking to her. She told me not to call him.
If you bond out, you must remain in contact with your lawyer, Ms. Hawkins. I'm gonna give you a piece of paper today with her phone number. Either commit it to memory, do whatever you need to do. Mr. Odom, I promise you, I will have a hearing to hold you at no bond if you don't follow these conditions. I'm not asking much.
Yes,
All I
sir.
want is the streets to be safe. Do you
Yes, sir.
understand?
Yes, sir.
Okay.
A Texas judge delivered a stern warning to a repeat domestic violence defendant after he was arrested yet again while already out on bond for multiple pending cases. The defendant appeared in court, facing a new charge for violating a protective order after prosecutors said he got into another violent altercation involving the protected complainant while allegedly drinking and acting aggressively. According to police, the complainant's son confronted the defendant during the incident, leading to a physical fight that left visible injuries. The defendant tried minimizing his prior court absences, insisting he had only missed court once, but the judge quickly shut him down, pointing out that he had continued picking up new charges while already on bond for harassment and felony assault, involving impeding breath. The judge warned the defendant that Texas law only allows no bond detention in limited situations, but said violations of protective order conditions could absolutely qualify. Promising to protect the public in a heartbeat, the judge imposed strict release conditions, including a GPS monitor, scram alcohol ankle monitor, curfew, a 1,000-foot exclusion zone from the victim's home, and complete bans on alcohol, drugs, weapons, and any contact with the complainants. The judge repeatedly warned that even failing to charge the monitoring devices could land the defendant back in jail with no bond. When the defendant claimed he had no phone and relied on his wife's phone to communicate, the judge bluntly responded, "You can't use this person's phone, dude," while stressing that he expected full compliance with every condition moving forward.